Hi, everyone. Thank you for joining today's webinar presentation, Patent Drafting, Tips for Avoiding and Arguing Section 112 Rejections. I'm Gail Martin, Associate Marketing Manager at LexisNexis IP, and I want to cover a couple things before we get started. Please feel free to submit any questions you have during the webinar by using the Q&A feature. And you can download a copy of today's slides from the panel. These and a link to the recording from today's presentation will also be sent to you. Now I'd like to introduce today's presenters, Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean was recently named one of the world's leading IP strategists by IAM. Robert C. Ryan. Robert is a partner with Holland & Hart and founding director and partner of what became and remains among the largest and most prominent intellectual property law firms in the Midwest. He has an intimate understanding of intellectual property law and practice and the challenges his clients face. Todd is a shareholder. Todd Van Tomey. Todd is a shareholder in Nyemaster Goods Intellectual Property Department. Todd counsels clients on how to avoid intellectual property disputes and resolve them in a cost-effective manner. He has extensive experience drafting and prosecuting patent applications across a wide array of technologies, as well as extensive experience drafting patentability, non-infringement, and invalidity opinions. Thank you again, everyone, for attending today's presentation. With that, I will turn it over to you, Jean.
Okay, thanks, Gail, and thank you all for being with us here today and spending a portion of your Thursday with us to discuss this topic. I got a couple more housekeeping matters just to go through with you quickly. We're going to talk about, obviously, 112 as advertised, but this is an issue that comes up in a lot of our discussion. So if you're interested in this discussion that we're going to have here today, you might want to think about going back and listening to one of our previous discussions where we talked about this specifically as it relates to software. Now, no doubt software will come up today, and I certainly anticipate that it will, but we did an entire webinar on the key cases in patent eligibility and what you can learn from them as it relates to drafting software patent applications. And we did that in February of this year, so that's still a very relevant webinar that you might want to go back and listen to, and that was also sponsored by LexisNexis IP. And then we have a very exciting announcement to make, and this is confirmed and now on our calendar, and you can register for it. Alice is turning 5 this June, and we have a number of things going on at IP Watchdog, as you may or may not be aware of yet. One of the things in conjunction with LexisNexis is we're going to do an expanded panel on June 20th, and Commissioner for Patents Drew Hirschfeld is going to join us for that webinar for the full 90 minutes. I just talked to him yesterday, so we're on board for the full 90 minutes with the Commissioner. And then I have Russ Slifer, former Deputy Director, joining us, Meredith Addy, a patent litigator, and Kent Richardson, patent broker and valuation expert. And we're going to talk to the Commissioner after his presentation and then take questions from the audience. So that's going to be a very special one. We also are asking for CLE for that one. So hopefully you'll be able to join us for that as well. And of course, none of this happens without sponsors. And LexisNexis has been a great sponsor for us over the years. And the tool that they have that is most directly related to the topics that we're going to talk about today is PatentOptimizer. And it really is a wonderful tool that helps you make sure that the applications that you're filing are tight and don't have any unnecessary 112 problems. It looks at cases and languages and offers alternatives and definitions. And one of the things that I really like that it does is it makes sure that all of the elements in your drawings are talked about in the specification, and it makes sure that everything that is in the claims is mentioned in the specification, the drawings, and vice versa. And we'll talk about those kinds of problems today for sure. And one of the new things that PatentOptimizer does is it also now allows you to create pre-populated responses to office actions to get you going, and that's a new feature, a new tool. It maybe doesn't neatly fit in with what we're talking about today, but as I always do, the sponsors make this possible. So, and frankly, I can't imagine that you wouldn't need a LexisNexis solution. So please, if you do need one of their many solutions, I'd appreciate it if you would give them a test drive. So with that introduction, gentlemen, I'd like to pause here for on our outline, which everybody has already seen. This was on the registration page, and bring you into the conversation. Now, before we go any further and I bring you in, I want to make a confession. Normally I'm not going up until the very last minute with the PowerPoint presentation like I did with you guys today, so I apologize. There's usually the minor tweaks and whatnot, but when I put this together, I did sort of a minimalist approach, and then we kept adding to it. And sometimes I wonder, whenever we talk about 112, whether we sort of create the same slide deck. And then it dawned on me that, well, the reason why we kind of create the same, not exactly the same slide deck, but we hit the same issues is because those are the issues that continue to plague attorneys. That's the reason why we had 800 registrants for this webinar. And this is why it continues to be such an important part of an point of emphasis by the Patent Office. So I'd like to get your preliminary thoughts. And for those of you who don't know Bob and Todd, they handle different technologies. They overlap a lot. Bob is a computer software hardware guy. Todd is mechanical, food science, pharma, chemical guy. And 112 matters to all of us. Big, broad, maybe not even a question, but Bob, will start with you. Todd, I'd like to get your preliminary thoughts as well after Bob. So Bob, I want to kick it to you.
Yeah, thank you, Gene, and Todd, for allowing me to join you, and all the attendees, thanks for joining. 112, or indefiniteness, focusing on indefiniteness, is one of the most important issues of all, and it ties to so many other problems, defenses that arise in litigation, claims of invalidity that arise in litigation. I see today, after 40 years of practice in the field of patents, I have come to the conclusion that understanding indefiniteness law and the problems it creates and the solutions that are available to eliminate or reduce them is the most singular, most important aspect of patent practice that there is, notwithstanding that in our day-to-day work in the patent office, for example, we're usually more focused on talking about obviousness and anticipation types of rejections as the most fundamental problem, at least vis-a-vis prosecution. But 112, which arises, of course, all the time, well, not all the time, but very frequently in patent prosecution, also arises greatly in litigation. So that you succeed in getting a patent, but to what end when it's not enforceable or subject to very serious problems that cost clients a lot of money and maybe even make it impossible for the client to afford to litigate and enforce their patent or otherwise even seek a license deal under it when all these issues are created. So as we go today, I would encourage you to see how these issues lead to also invalidity problems in other arenas, such as written description, reverse doctrine of equivalence, and Alice, and we'll talk about that as we go.
Okay, thanks, Bob. Todd, your thoughts.
I'd like to build a little bit on what Bob was saying. I guess I see it in my practice a fair bit. I guess I observe it, and it gets more visibility, I think, in litigation cases like Bob mentioned. I guess I'd like to hit on the point one here on the slide a bit, Gene, and maybe you can circle back and tie into it as well. I guess for me, what I've, learned over years of doing this is the detailed specification and having a very detailed and many conversations with the client about the invention are advantageous to avoiding 112 issues later on down the road. And despite your best efforts, you may miss an issue that perhaps you could have addressed. But I think being very cognizant and going through almost term by term as you develop the specification and certainly the claims, to think about would there be any 112 issues with how I've phrased the claim or the words and terms I've used? In my practice, lots of times we get sort of fuzzy or what might be subjective terms that the client says are the quote-unquote invention, and you have to drill down deeper to get at what are the objective tests and things that can help define it better from a patent standpoint. So,
yeah, and this is something that we're gonna hopefully have time to talk about too. And I know we have a lot of slides to get through, but what that means in different technologies is going to be different things, and that's some of the challenge. And I hopefully for me that I think that the takeaway message is, and I'll start with the takeaway message because I want everybody to keep this in mind as we talk about this, is it's always that person of ordinary skill. And I think in this area, it's even more important than any other area, specifically because when you're describing the technology and you sit down to write that application, if you write an application in software today, and then that independent inventor, maybe they're a friend, a neighbor, a relative, comes in, you got to deal with it a little bit differently, and realize that the rules, whether it should or not, they get applied differently. And if you are always dealing with one and then you work on another, you have to take a pause, I think, and make sure that you're doing service to the client and not just assuming that the same lens is going to apply, I guess, for lack of a better way of saying it.
Yes.
So let's jump into it. And because I have this slide here, Bob, I didn't mean to cut you off. I want to just I just want to push this so everybody knows. I have this here just for reference. We'll come back to it maybe if the language matters during our discussion or answers. But what were you going to say, Bob? Were you going to add anything?
No, the only thing I was going to add is that if give them an example. In the computer arts now, we have some fairly stringent rules that apply as to what must be disclosed by way of an algorithm. Although that what an algorithm is and is not is, of course, not yet anywhere near fully developed. But there are places where you must have algorithm disclosure. And that kind of ruling does not necessarily apply in other technologies, such as chemistry, for example, or mechanical. And the reason is because not only are those arts more developed, but as Gina said, it's about one of skill in the art and what they understand from what they're reading, what's solid enough to give real meaning to the claims in view of issues such as we're going to be discussing here soon.
Yeah, and it's unfortunate, but like in the software area, there's a whole different way that 112 gets interpreted. If you don't have, and we have a slide on this, so maybe I'll just wait until we get there because I know we will get at least that far. But gentlemen, the topics that we have for discussion here are the common problems that are faced, just so we're all on the same page quickly. And then not that we necessarily have slides for each of these problems, but these are going to be the topics or themes that I think keep coming up over and over again. Making sure that whatever we do doesn't run us into a 103 concern, because if you explain is idiotic as it is, I think the better you explain the invention, you may wind up making it sound obvious. And then we want to talk about best practices, obviously. And then when the issue comes up with the examiner, what do you do? So, Todd, these are the common problems that you hear people face over and over again. And obviously, the disadvantage is increased prosecution.
Yeah, I mean, obviously, if you're using a term that arguably is ambiguous, the examiner makes more rejections and it adds to cost, right? I mean, it's going to increase pendency, all those things you've got listed on the slide there, Gene. I mean, it's a challenge. I mean, for me, the dichotomy often also, we talked about this a little bit prior to getting on the webinar, the dichotomy is a little bit of how much do you rely on sort of the interpretation a term might be given by one of ordinary skill in my art versus adding something of a definition to the specification, which I know some practitioners are loath to do, to help define it. And sometimes those are competing, and sometimes they seem unnecessary. But I think sometimes you have to look at it and say, okay, can I define this in a way that is the ordinary meaning, and should I put it in my specification? Because oftentimes that will reduce the cost.
Yeah, yeah, but then you have the practitioner say, but then that obviously limits you. And Bob, that seems like that's where the courts, because I know you do some litigation, but that seems to be where the courts are going, right? They want more limited rights.
They do. They want more limited rights. They want more precise claims. There's been a distinct push to that end in the last 10 to 20 years to get claims more clear. And if they're not sufficiently clear, they're tossing them. But I want to add this. I think there is value to having claims that do both. I think there's value to having claims that are relatively definite, and to have some claims that may not be so definite, but you think have a chance of passing under the reasonableness test we're going to talk about here in a few minutes. You can do both.
Yeah.
And
let me ask you this,
strategy.
Because I want to get both of your takes on this, because you talk about means plus function, and I know what that means in the software area, and maybe there's reasons not to do it there, but I still don't know that I would say don't do it. But when I talk to litigators, you would think that they would say, oh my God, don't give me means plus function claims. But I've talked to litigators that tell me, please tell your patent prosecutor friends to give me means plus function claims for that very reason, because they're maybe a little ambiguous. And
that's exactly right. That is exactly right. Do both. Do your client a favor and give them both, and maybe even give them a claim where it's not precisely clear whether it's means plus function, but it might be. So
Todd, in your art areas, is that something that comes up a lot, or how do you do it? I mean, I know some of what you do literally is squishy.
Yes, I know we talked about that a little bit, but yeah, it doesn't come up a lot, and I tend to fall on the side of trying to avoid means plus function. But yeah, I think it does have its place, and having one that's there, like Bob says, I don't think it hurts. It just gives a claim of different scope and requires further interpretation or different interpretation later on, and I think it's valuable, actually. I've kind of come from the I would never ever do it to I often consider it, at least.
Yeah, yeah. And when I say that a lot of what you do is squishy, I mean, it's like I was literally talking about squishy, because with the food science area, as we've talked about ourselves one-on-one, a lot of times you're trying to capture the way that something feels in someone's mouth, for example.
Yeah, I mean, you can talk about various organoleptic properties, right? Or is it moist? Well, how do you define moist? Where is it moist in the product? Is it crunchy? Well, crunchy, really? I mean, probably, I don't know. How do you define that? You need an objective test for that. I mean, what I've tried to do with some of those kind of, let's continue with our technical terms, squishy terms, is to encourage the client to develop an objective test in some cases that we can put in a specification so that makes it definite. We can put a testing system in, we can provide objective limitations on that, and give it some definiteness, especially because those sort of squishy inventive terms are often what is inventive in food science related inventions. I mean, but how do you describe that? How do you get it to where it is definite, where it's going to pass 112? And sometimes that requires more work than typical cases, candidly.
Yeah. Okay. Well, let's get to that. And on the way to the common problems, what I want to do is just take a quick little detour and say, here's a couple things from some examiners that they always tell me. And if you've been on other webinars where we've talked about this, I mentioned this a lot, so we don't necessarily need to dwell on this, but I would like to get Bob and Todd's take on it. The commonality of these examiners and all the others that I've ever talked to comes down to, remember that they have a limited amount of time. And they always talk in some way, shape, or form about 112 errors. Please proofread the claims number 5 here on this slide. And this examiner even talked about the importance of drawings because, whether we like it or not, examiners don't necessarily have the time to read the entire spec. So to make it easier for them, there's a number of things you can do, right? And then this examiner from a different examiner talked about foreign translations. And again, that's a 112 issue. If they're spending all their time on that kind of problem, then you're almost guaranteeing the office to force an RCE, and it's not really the office forcing the RCE, it's the 112 issues that were in the application forcing it. Gentlemen, I mean, do you encounter this kind of feedback from examiners as well? Bob?
I do all the time, and I agree with everything you're saying. And so looking at the statement about a detailed specification, I use the word thud factor a lot in training my people that I work with in this firm, and I used it elsewhere when I was back in Chicago. A patent application should have thud factor. It should be something that somebody looks at and goes, wow, a lot of work went into this. There's a lot to this invention. I don't think it's of any help to trivialize the invention by way of a skinny disclosure with very few drawings. That's not to say never do that, but I'm just saying if you've got a very important invention to a client and they want a robust patent application and they want lots of opportunities to get as many claims as they can, perhaps if it turns out to be as valuable as they think it is. I think the more you do to create thud factor, the detailed specification, go into as many details as you can. It's easy in my view to avoid the problems of a specification narrowing the claims. You can do that easily. There are techniques for that. So that you have broad claims and less broad claims that are not impacted negatively by the detailed specification. Yet the detailed specification can give you a ton of room to move during prosecution if needed, or after issuance in a re-exam or other inter partes proceeding. But if it's not there, you can't do it. If you don't have the support for where you might want to go later to perhaps add another limitation, if it's not there, you can't add it, right? It's too late. So,
right.
And it doesn't impress investors, it doesn't impress bankers, it doesn't impress a potential jury or a judge. So I'm in thorough favor of everything I see on this page.
Yeah, and the way I always describe that, and people have at times tried to mischaracterize this, but I always say that your average district court judge should not be able to understand the patent application. And the reason I say it like that is because your average district court judge, prior to being educated about the invention in the trial, is not a scientist. Most of them are history majors, English majors, business majors. They're not engineers. They're not scientists. They should not be able to pick up the patent, read it from the first word to the last word, and have no questions. They should at some point in time go to themselves, wow, I really, this is impressive. There's something going on here. I don't really understand that science involved. And it's not to say that they're not going to get it with effort and with the experts and the arguments and that sort of thing. But if a judge understands your patent application themselves, I think you're in trouble. Todd, or Bob, go ahead.
I was just going to say, I think there are some very simple inventions where that may not be the case, but in general, that's no doubt true.
Right. And when I talk about that, and I do mostly software related stuff, but you're right. I mean, so if you're dealing with a game or some toys or some maybe as seen on TV stuff, that's certainly true. Yeah. So that I'll happily add that kind of caveat. But Todd, your thoughts?
Yeah, I'm on the I guess the previous slide, the importance of drawings. I think that can't be overemphasized. I mean, and I think the more drawings you can include that you can point to later on to explain things only help. I also think proofreading the claims and specification, and not to be a shameless plug for LexisNexis, but the PatentOptimizer tool is great for that. I use it a lot, especially for simple things of antecedent basis and whatnot. It's just really helpful for that kind of thing. Also, the specification, as you're developing it and making it and growing it, it's important to talk to your clients about alternatives of what they originally thought of, I think, and that helps broaden sort of the basis and subject matter of the case. Also, keeping claims reasonable. I think, Gene, you've had a couple articles on IP Watchdog about the goal, I guess, of having shorter claims and the correlation between initially shorter claims and increased prosecution costs. And I think you have to be very thoughtful about what type and the length of claims and things like and how you're presenting them. I think you can't just go, oh, I want a short claim, and that may not be what you really need to advance it in a cost-effective manner in the case.
That's right. And I actually, when I spoke at the Utah IP Summit this year, I gave a keynote address out there, and I was talking to some software attorneys out there, and one of them was talking to me and telling me that one of his clients, they don't want the first claim to be a short claim. They want the first claim to actually be quite a long and rather detailed claim. And the purpose of that is to explain the invention to the examiner, and also to get the examiner off on the relationship off on the right foot. Because if you're asking for the moon, you're just not going to get it. And that really just makes, I think, the whole relationship sour from the get-go. I think
that's a point, Gene. Actually, I think sometimes if you've got a strategy that is, I'm going to go for maybe narrower claims than you think you're entitled to initially in your first application, but get the examiner on board with what the invention is directed toward, that it's actually inventive, and allow the case relatively quickly. It serves two purposes: gets the examiner on board with all those thoughts, but also gets the client some meaningful protection, probably of their commercial embodiment right away, and then allows you to go back and perhaps broaden the claim a bit later on with some goodwill established by the examiner and some knowledge of the invention already. I think there's a lot of merit to that strategy.
Yeah. Now, let's continue to push forward through these slides and get to as much of the discussion as we can. So this is just, a reminder that the Supreme Court has did away with the insolubly ambiguous standard and added, their own view of what it should be about informing those who are skilled in the art in Nautilus. But the Patent Office does not follow Nautilus. They follow In re Packard, because it's their view that In re Packard is a more restrictive test, and Nautilus was a litigation, and that it doesn't force the Patent Office to follow them. In prior cases have allowed the Patent Office to apply a more restrictive test when handing out patents. So when you're at the Patent Office, you're not getting Nautilus, and I don't know really whether it makes a difference. The test in Packard is the claim indefinite when it contains, essentially, is it clear or is it unclear? Claims are required to be cast in clear as opposed to ambiguous, vague, or indefinite terms. I don't know, guys, do you have any view or feeling as to whether one is better than the other or different than the other in real world? I think it's to some extent, maybe it's making a mountain out of a molehill. It doesn't seem to change anything, I guess. At least I haven't seen it change anything. But these are the two different standards: litigation versus at the Patent Office. Now, at the Patent Office, BRI applies. And Todd, you had mentioned you wanted me to add a slide specifically about this because you find you still have to argue this.
I do a lot, or I see it in other practitioners' cases where it happens all the time. There's cases where the specification says dehydrated, and the examples, for example, might give, no pun intended, give examples where clearly there's moisture left in the product. Well, the examiner takes the interpretation that dehydrated means it's free of all water, which is obviously contrary to the interpretation in light of the specification. I run into this all the time, and I think it's important for practitioners to know. I think the citations actually needs one more one on the end of it. People online want to know about it, but
okay, yeah, I'm sorry, that's my fault. It's yeah.
No worries. We talked about it at the very beginning. But I do think there's a dichotomy of, like I said previously, of do you rely on what one of ordinary skill in the art would understand the meaning of the term, and when you talk to the inventor, they say, well, everybody knows what that word is, and you shouldn't be forced to define what every single word that is known in the art to be. However, oftentimes, if you haven't, you end up fighting about it, and it adds cost and difficulty to get the case allowed. And sometimes I've had to appeal cases because of that, which is ridiculous. But this section, I think, helps a lot.
Todd, I'm with you. I've had to appeal cases over this and get examiners reversed over what are absolutely ridiculous contentions, such as that the top of a table is not planar to one of skill in the art, a typical desk with a flat top. No, it's not planar, and the reason it's not planar is because at the micro level, it's got little mountains in it. Crazy stuff. I'm seeing absolutely crazy stuff, and it's getting worse, actually. In my things I never saw in the first 20 years of my practice, I'm now seeing, I wouldn't say routinely, but a lot. So this is a very important slide, I think, for people to know and utilize.
See, now that's interesting. Now, I didn't put this slide in there specifically because, and I'll tell you why, because the examiners that I talk to, and maybe it's just that I'm talking to examiners that are more reasonable, and the quote unquote maybe the problem examiners that want to talk to me, and maybe that's just the way it is, I guess. But the examiners that I talk to tell me that they are sick and tired of attorneys citing this to them. They know this. They don't like it when attorneys cite to them that it's got to be the broadest reasonable, not the broadest unreasonable interpretation. But
well, Gene, I think the important piece that needs to be emphasized when discussing this is that it's interpreted in light of the specification, not the broadest reasonable part, but it's in light of my specification, and that's important.
So okay, so now what I'm going to have to do is I'm going to need to go back to the examiners who I've talked to on this, and so to be continued, because I guess the question then becomes, maybe it's not so much that they're saying don't cite this as much as it is just don't be condescending when you're doing it.
Right.
All right.
For
so
sure.
Yeah, I think that goes back to your cordial recommendation a couple slides previous, right? I mean, I think if you bring it up sometimes in an interview, that's perhaps the best way to first bring it up and have a conversation about it and say, listen, we just don't think that the interpretation you're giving term X, Y, or Z is reasonable in light of my specification, but have reasons why and point to in the specification why. In my experience, 50% of them won't budge anyway, right? And you'll end up appealing it, which is where you get like dehydrated issued or something like that. Or I've seen a case where, the claim said salt, and the examiner said that the prior art, which had a chemical salt, which was toxic, basically not toxic, but anyway, it was not sodium chloride, which was clearly what was intended, right? And it's just, when you read the specification, you know that it's not the interpretation they're giving it, and you end up fighting about it a lot of times. And are you better off giving a definition? I don't know. Should I have to define what salt is? I don't think so, but who knows?
And I will say this, you see this problem far more in the chemical and mechanical arts. I don't recall a case where I've had this problem when we're talking about software or computing technology.
Yeah, yeah. Now I guess the question becomes, what do you do? What do you do? I mean, I know we're talking about appealing, right? But are you finding that you're being forced to go all the way to a decision, or is it enough to file a brief, or are you getting these cases out on the pre-appeal brief conference? Are the examiners, pulling it back in before they have to write their answer? I mean, or what's going on? I mean, where do you see this shaking out finally?
All of the above. I
So
have
it's not.
cases.
Yeah,
It,
so it's
it
everywhere.
depends.
Yeah.
And it can be particularly difficult when you're dealing with English as a second language problem with the examiner, because then the examiner can, they in good faith they think they're right, but it's not the way the art interprets the term, and some file a declaration, great. I've had cases where the examiner just didn't buy it, and I had to take them up on appeal, and the pre-appeal conference did not work, and we had to go all the way to the board, and the board wrote a very harsh opinion on the matter in our favor, but they were not happy about it.
I've had all that too, Gene, and I've even had smaller clients and even some bigger ones abandon cases because of it, and just say, listen, if they don't get this, they're never going to get it, kind of thing, and get that frustrated, and that's not obviously good.
Yeah.
I have had success also in pulling in the supervisor, though, and having a cordial conversation with the supervisor about it.
Yes.
And that was my next question, whether, because sometimes, and Bob, you work, I know, in the software area. In certain software art units, it has been not always an examiner issue. It has been a supervisor issue. So I was wondering whether you guys were thinking that what you're dealing with was an examiner issue or a supervisor issue. And it sounds like what you're agreeing here is that it's an examiner issue, not a supervisor issue.
Well, I've had it be a supervisor issue. I've actually had examiners tell me that they would like to move forward with what we're proposing, but their examiner is saying no. And I mean, very candidly, tell me that in a telephone call. So
I have as well.
It could be that as well.
Yeah, I have as well.
Yeah.
I mean, one of the things you can do is you can get access to some of the patent examiner data and art group data. Gene, I know you've had separate webinars on this, but PatentOptimizer type data that can sometimes reveal that, of who, is this a group issue or is this an examiner issue?
Yeah. Yeah. Okay. Well, let's move on, because we could spend all day talking about that. But I want to get to, this is just some general information about definiteness from the MPEP. Again, here for our reference in case we want to really come back to talk about it. But the issue that have already mentioned specifically is means plus function. And we have a couple slides on this, and we will go through both of these slides in a little bit more detail. But to make sure that we get to it, and looking at the clock, the slide of consequence here is to keep in the back of your mind that all of this, whatever you're doing, can lead to Alice issues. So maybe we should start. Maybe I probably should have put that slide first with this all into context. Bob, do you want to say something about that and put this in context?
Yeah, I just had the fortune to argue an appeal in the Federal Circuit, the Konami versus High Five case. It's a software case in the gaming space. And we pointed out to the court that, by the way, we won. We got 52 patent claims and 4 related patents held invalid, both under 112.6 and 2, or B and F as they are today, and under Alice. And the point under Alice was that our point that we argued to the court, and I believe it accepted, was that what we were dealing with was really a wish list patent. It was identify what a slot machine might do at the high level interface and claim it. And I think the fact that that's what was done in this patent, in our view, is the reason that the court affirmed the district court completely across the board in a Rule 36 affirmance that the claims were both invalid under 112 for indefiniteness as well as invalid under Alice, because they're just, it was an idea patent. It was a wish list. Wouldn't it be nice if I could, and I said this at the argument, this is a patent that says, wouldn't it be nice if we could fly to the moon and land a lunar excursion module and bring it back and then claim it? You know, and I think that that's a big problem in a lot of patents. Now you can do that, and frequently you can get those patents through, but recognize what you're getting when you do that.
Yeah, yeah, and I mean, it doesn't really. I mean, these patents in the software area, or what I should probably say, the innovations start with a wish list. Nothing wrong with that, but your
Right.
patent cannot end there.
Right.
I mean, it just can't. I mean, because if it's going to get litigated, it's going to go down.
Right.
So let's take a step back and look at some of this in a little bit more detail. And at the top of this slide, I just have the language from 112F again for our reference. And then, guys, the critical case here over the last few years is Williamson. And this is what turned means plus function upside down.
It did. It took it back to where it was pre the strong presumption law that got adopted in the mid 70s, that there was a strong presumption that a claim was not a means plus function limitation. It took it back to what the law was actually before that, and said, no, we're not going to do that. The question is there function in the claim that's not supported by sufficient structure in the claim to perform the function, or in the spec? It's got to be either in the claim or the spec, and if it's not, that claim's going to be invalid.
Yeah.
And I will say this: I believe it's become an epidemic of in current patent prosecution. It's been going on for some time. It's easier to claim things functionally, and so people do that. And I see a lot of less experienced attorneys accidentally putting function in, and they don't recognize that that's what they're doing, because it can be much harder to distill the essence of a function to the structure that provides it, and claim the structure, or at least include the disclosure included in the disclosure. And that's another reason for detail in the spec, because if there is function in the claim that is found there, notwithstanding your disagreement with it as a drafter, at least there's some place to run for the prosecuting, the litigating attorneys, or whoever,
Right.
negotiating attorneys in a licensing negotiation.
Yeah, now, you know, this is a good place to, I think, interject this question, and let me give a little bit of a preface, because I always say when I'm teaching, you know, new attorneys and law students, I tell them, look, whether you're going to use means plus function claims in your applications or not, and I'm talking specifically now about software, you really should be striving in your descriptions to have a description that would allow you to use a means plus function claim, because you want to have the technical disclosure there so that if you do wind up using one purposefully or not, that the claim is not going to fall. So the question that we have with that preface is, how do you do this when your client has a tight budget? Particularly, for example, the questioner asked about universities. And we all know that, you know, universities are very inventive, but money is a very important object to them. Any tips or tricks on what you can do? Todd, any thoughts? Bob, any thoughts? Todd, we can start with you.
As far as cost savings,
or doing it on a budget. I mean, if the answer is there is no real way to do it, because to some extent that's, you know, there really is. There are no shortcuts. So every shortcut comes with consequences, right?
Oh, absolutely. And I think making sure to describe the structure in your specification performing whatever function it is that you're talking about it performing, I think is key. That doesn't add a whole lot of cost to the application. I think might get you a long way there. I don't know what Bob wants to to add to it. But I mean, I think as long as you're cognizant of the fact that you're wanting to describe both, not only the structure, but also how all the individual pieces of the structure work together, and if there's synergy to be had to describe that synergy, I think that becomes significant. And I don't think that adds a whole heck of a lot to the cost. Now, I'm not talking, you guys can talk to the software piece. I'm sure it's significantly more complicated, but, and maybe then in that instance, it's just not able to be, a corner cut, shall we say, without a drastic sacrifice.
Yes. Yeah, it becomes more complex in the software spaces and others where you're talking about more complex technologies that are not supported by standard words that have been developed, such as in the chemical and mechanical spaces, as examples. But I would also say this is that there is a way to reduce costs that we have developed, and I don't think it's novel. I think a lot of firms do this. I was probably taught it actually. Is that you have an agreement with the client that you're not going to be responsible for whether the specification meets certain requirements. The client's going to be responsible for that, and they will do the best they can to give you a draft, and you work from that. You can do that and not be worried that you're going to be sued for malpractice. It's got to be done carefully, but you can do it.
Yeah, I mean, and I'm trying to. Okay, because I apologize for flipping to that slideshow. That's not, what I'm trying to do is I have a question that I know I have a slide in that deck that addresses it, and I want to pull it up before I ask the question. So, but there are ways to try, if you have clients that are cooperative, and that's the key, right? I mean, is getting cooperation from clients. And the worst is it becomes very difficult to do things on a budget if you have a client that sends you 2 or 3 sentences or maybe even 2 or 3 paragraphs and then wants to pay very little or nothing and doesn't even want to let you talk to the engineer or scientist because their job is not really to help the patent attorney. Their job is to invent. I don't know about you guys, but I've encountered that situation, and that's just, there's not much you can do.
No, you're right. That's right. There's no way around it.
Yeah.
Like you say, skip it. If you're going to skip a step, that has consequences.
Yeah.
And there's no way around that.
So the question that I was trying to get to when I was pulling up that slide deck and I couldn't get it to go away is, what is the panelist's view on configured to language as a means plus function substitute? And I don't have that, I don't think, in either of these means plus function slides, but I have an entire slide on that specifically, and it's adapted to slides, adapted to versus configured to. And for reasons that I don't necessarily understand, I can't profess to understand, adapted to is language that does not seem to provoke means plus function treatment. But in the MPEP, at least, whenever configured to is mentioned, which it is not mentioned a lot, but it is mentioned several times, it is mentioned in means plus function terms. So configured to seems to be interpreted, at least under the means MPEP, as invoking means plus function, and adapted to not necessarily, at least historically. Do you guys have any thoughts on either of those terms or what may be happening out there today?
Configured to, I've seen more and more having examiners apply a means for analysis to configured to limitations. I guess I hadn't noticed whether adapted to correlates with that, to be honest, Gene. But configured to, I definitely see that. I think it's important. There's nothing wrong with putting some of that functional language, I don't think, into the claim. And sometimes examiners, frankly, ask for it to give it a little more meaning for them to allow the case. And I don't think it's necessary lots of times, but as long as there's sufficient structure to avoid the means for, associated with that configured to, I think that might be okay. But the key is to make sure you have sufficient structure and not just simply have it in functional terms, right? Or
Yes.
generic term configured to do this, a member to do this, or something like that. You might get into overclaiming at that point too, and be invalid for that reason as well.
Yeah. So, and John White, who many of you know, the patent bar guru, who probably helped many of you on this webinar pass the patent bar, has a way to explain the difference between adapted to and configured to, and that's one of those things. When he says it, I get it, and then when he walks away, it's gone, because those two words just seem to me to be very similar and very much very close. But I guess if you're in a pinch, what my takeaway has always been, adapted to would be better than configured to. But I think you in the Williamson world, you run the risk, right, Bob? I mean, what are
Yes.
you seeing during litigation? I mean, it is a risk.
Yes, it is. I'm not seeing the problem in the patent office so much. I agree with what Todd said. Examiners will frequently ask for it. But the key is what follows it. What follows operable to, configured to, programmed to, or adapted to? If it says perform something, do something functional, it's functional. Now, it's very frequently it's the language that follows, not that language itself, that tells you whether it's functional.
Right.
And then the key is, okay, do I either have structure in the claim, and you might put some minimal structure in the claim, or do I have, at least if this gets argued in litigation, is there sufficient disclosure to perform the function to one of skill in the art disclosed in the spec someplace to support it? That's the key. Very frequently you see, and you see the litigators even, many of whom I think don't understand it when they're arguing it, is what leads to a lot of this. They're focusing on whether the word is a nonce word, or it says memory or computing device or processor. No, that's a piece of it. But frequently the true key is the performing part of the claim, or the functional language that follows.
Yeah, and that in Williamson here, I pushed back to the last slide we did, because module was determined to be a nonce term. And if you think about it, just like without the context of the claim, how is a module nonce? Well, it's a control module for receiving communications.
Right.
It's the for receiving communications that makes the module nonce.
Right.
I mean,
Agreed.
I think that's the only way that it can possibly make sense, right? Because module is something that we have always, like mechanism, right? Machine. It exists. It's something that's there, you know?
Yeah, what really made that claim functional is, as you say, the words that follow. Now, you might recite a distributed learning control module, and that might, without any of this other language, and that could be functional all by itself too, because it's not sufficiently structural in the computing world to know what that means.
Right.
And it probably isn't, is my guess.
Right.
I'd have to look at the spec and the circumstances, which could change that answer.
Yeah.
But you see, it's not. It can be the key to the store that really sells it can be the language that follows.
Well, let me just interrupt you there for a minute, because I had this thought that entered my mind that I don't know why it never entered my mind before. But do you suppose that because when you read some of these specs, it's like, how did they ever expect that any of these claims were going to survive? And and maybe it's unfair to even ask this question, and I probably have to go back and look at this myself, but do you suppose that these means plus function claims get used an awful lot more in cases where the specification is thin, and that is in and of itself the problem?
It can be. And by the way, I have a theory that that's why we have Alice.
Yeah.
That the Supreme Court is tired of looking at patents that are vacuous by way of teaching, and then they claim flying to the moon.
And that's that would sort of make Alice and KSR really, 1A and 1B, right? We're just tired of dealing with certain types of these quote unquote inventions.
Yeah, and in a way, I have a feeling that, we've gotten to the Alice space because of people not presenting the actual issue in a more concrete way under conventional patent law. And so it gets up to the court, and the court looks at these patents and says, these are vacuous. We're not going to let this happen. And so I think it's unfortunate personally that we have Alice. I think its outcome may have been correct for other reasons. I haven't studied the matter well enough to know, but it is my impression that it is vacuousness of these disclosures that are leading to these decisions that I think might be right in the end in terms of the patent claim should be invalid, but not in the way stated by the analysis.
Yeah. So Todd,
guys,
I want to.
Can I add something real quick? I think you guys probably know the answer to this better, but isn't this an opportunity if you find yourself drafting this type of claim to step back and then ask the client, well, what's the structure that's helping us perform each of these functions to make sure that those gaps are closed? I mean, that might be a practice takeaway tip that I'm learning from this conversation, frankly. But I'm curious what you guys think.
I agree.
Yeah, absolutely. And I think some of the problem is sometimes they don't know, and a lot of those applications may have been that, and some of the applications may just have been what really was an innovation, and the target they were trying to hit was an older target. So it is hard to know which one is the problem. I mean, in some of these cases, you can know, and I think that describes the disparate treatment. So, for example, if you try and rationalize cases like Talus and that's one jumps my and also McCrow and some of these other cases that went patent eligible. With other cases that went patent ineligible, and we all know that 101 and 112 are bleeding together because it's all about what's disclosed. Did you actually disclose an innovation? I think they're hard to distinguish, except for the court knew that in McCrow, we're talking about lip syncing, cartoon characters. And in Talus, you're talking about a fighter pilot with changing frames of reference, and the physics is remarkable. Those are real innovations. So I think if you have a real innovation, they're kind of giving you the benefit of the doubt. Now that can't be a standard that lasts forever. And it's not something that you want to try and hit, obviously. But so with some of these inventions, it's hard to know whether there really was an invention there and they were just moving for a different standard and missed. Bob, I don't know. Do you have any thoughts on that?
No, I agree with you. I don't think I have anything to add to it. I think it's absolutely what's happening. I think that, and remember that a lot of the judges that deal with this, they don't know the law like we do. We live it day to day. Right. So they come to decisions that make sense to them because of what they've got before them, and and also whatever the advocates argue. And if the advocates don't argue the right thing, and they've got a serious problem with what's in front of them, they'll do the best they can to get to the right result under the law as they understand it, and they may not.
Right. Now, Todd, I wanted to make sure we got to this slide too, because I don't know whether I know we mentioned it earlier on, but in the food science area, it fascinates me because, like aesthetically pleasing was indefinite, but a lot of the terms that you deal with every day in the food science area in particular strike me as a little bit more than aesthetically pleasing, because it's, like, for example, I don't like lima beans because of, how mushy they are, for example. But so there's this, how do you make something that has the right crunch, has the right taste, and also has the right shelf life, and isn't going to kill you in the process with preservatives. And so these words in the different areas can be interpreted quite differently.
It's really hard. What I've tried to do is create my own objective measurements for those properties along with the client if we can, or correlate physical properties that provide that benefit or feature, and then claim those physical properties in particular beyond the mushy, crunchy, that kind of language, to get away from it, to give it some definiteness and boundary that can be established. And if you have to make up your own test, you make up your own test. I've done that a couple times where we said, you know, well, this is a product that increases crunchiness. Well, how do we measure that? Well, there's no real way. So, well, let's make a way. Let's think about it, and have come up with different tests for things. So that's what I've done with it. It is a real challenge, though. I mean, the aesthetically pleasing, I think, you know, if they'd have given an objective way that one could have determined what is or is not aesthetically pleasing in the specification, maybe that's now definite. I don't know the answer to that. I guess probably not, but it might have had a chance, right? If there was some objective criteria that established what aesthetically pleasing meant to one of ordinary skill, for example. And that's been kind of how I've tried to handle it, I guess, in some of these cases where the client says, you know, this invention is that it has added moisture, or it's mushy longer, or something like that. Well, why is that a benefit? What are the actual structural components of the formula that are allowing that to happen? You just have to probe deeper, I think, to get to the answer. And if you have to, you develop a test to give it an objective criteria which it meets. That's how I've tried to handle it, at least.
You know, and I think that's probably a really good takeaway. And I know we're going to have to stop here in a minute, but probing deeper with the client is the way everybody's got to do it, I think, in every technology area. And that's my final thought. But gentlemen, I want to give each of you a very rapid fire way. Todd, we'll start with you. Bob, I'll give you the last word. What is the one takeaway you want people to remember when they leave here today?
Well, I think it's exactly that. I think when they're drafting their cases, if they encounter a term that they believe may or may not need defining, engaging the client and talking about it with them. And if there's hesitancy to allow you to talk to the inventors, I think you need to have a candid conversation with that client that may be putting up some resistance to allowing you to contact the engineer or inventor. I'm blessed, most of all of my clients, I've never really had anyone that gave that roadblock, thankfully. But I think it needs to be emphasized that if you're running into that, explore it, explore what all of the features are. And it, not only will it help you create a better specification, it'll give you a better understanding and perhaps broaden the scope of what the client initially thought was inventive, and maybe there's more than one inventive concept as you have that dialogue than there were before, as you probe a little deeper. That for me, in the dichotomy of do you define something or rely on the broadest reasonable interpretation of a term? You shouldn't have to define every term, but man, I'd sure consider defining some terms to help smooth the prosecution process, especially if that ordinary term is the meaning you intend, and there's no other alternative meaning. Putting it in your specification, does it hurt? I would question, and I submit to you it might not, and it would only help.
Yeah. Bob, your final thoughts here today.
I want to emphasize what you've said, Gene, multiple times. Involve the client, advise the client, have the client involved in making choices, and making sure that you've documented somehow in your records that you've had these discussions with the client, and the client's making the choices with knowing, so that in a lower budget case, as an example, when you just don't have the budget to go develop some of these great things we've discussed today, that the client's been advised, and the client has made the choice and told you, no, I don't want to spend more on this. Proceed with what you've got.
Okay, gentlemen, I really appreciate you being involved here today, and I really appreciate everybody spending time with us here today. Thank you to LexisNexis PatentOptimizer, and if you haven't given it a try, do give it a try. The only risk here is that you're going to get hooked and addicted to it. It really is, I think, a great tool, and like my friend John says, is it really does help you avoid all those problems when you get the office action and it's got page after page of 112 issue that you have to fix. What must your clients think? You know, so it is a tool well worth investigating. And while I hope you join us in all of our webinars, I really hope you put this one on your calendar, June 20th. It's a very special extended edition. So look forward to seeing you soon. Have a good rest of your week and a good weekend, and take care, everybody.